Uh, Application for substitution.
Application for
Substitution. My lord, may I permit to mention it for inclusion, my lord.
inclusion under which heading?
Under group 1, my lord. Then
Is a motion stage?
no, my new motion.
New motion?
My lord.
Handboth stage.
For inclusion in the list.
Application.
Is it in the motion stage? Call the list.
The matter needs to higher scale of pay.
Sorry?
Higher scale of pay. In nutshell, my lord.
Hearing matter.
My lord, it was hard.
Why it is placed under the heading for orders? Pursuant to the direction of the ordinary bench.
It's the last order. And after filing the writ petition, the
Give me a second, sir. Yes, sir.
why the order was passed by previous coordinate bench. My lord, after filing the writ petition, the authority asked the petitioner to appear before them, and one hearing was conducted. But we don't know that copy I served on the last occasion. That is perhaps in your lordship's file. I'm placing the once again. But the faith of that hearing has not yet been disclosed by the authority. তাই না আছে?
এটা আছে এগুলো দিয়েছে Mr. Galib is appearing, no? On the last occasion, Mr. Galib appeared.
Junior Ashmita Chakraborty appeared.
Please have a notice.
I personally informed them, my lord, over telephone.
Any report has been filed?
No report filed.
It is the writ petition of the year 2008.
2008, long pending matter, my lord. My lord, may be pleased to dispose of the writ petition because the similar issue was decided by this honorable court. That order I have annexed, which is page 47. By
Page 47
my lord.
Of the instant writ petition.
My lord. The exact page 51. The same issue was decided and remitted the matter to the authority for taking decision, and that was
No, sir.
that
Sub notice once. The writ petition is.
Say one thing, my lord.
Yes.
My lord, kindly give a whispering in your lordship's order that what is the faith of this hearing.
Very good, sir. The writ petition.
private to the deed petition. Matter, my lord, I beg to appear on behalf of Kolkata Municipal Corporation.
Yes, sir.
And I contempt kindly direct my learned friend to serve me a copy, my lord, so that I can
So long your lordship
instruction
direction is
from
not
the
there, I cannot,
authority.
my lord. My lord, page 25 is the first order, which was, my lord, passed by your lordship, my lord. There was a direction for, my lord, completion of the proceedings before this London Special Officer buildings.
What is that order?
My lord, page 25 is the first order.
Page 25.
Page 25 of the, my lord, content application. It was, my lord, supposed to be completed within the last day of February 2025, but unfortunately, my lord, there was a printing mistake in the order. In the premises number was supposed to be 41, 71. It was recorded as 41. Thereafter, my lord, mentioned the matter with your lordship again. And page 27, my lord, the next order was passed. 18th of February. Here the correction was made, and my lord was pleased to, my lord, extend the time for the last day of April 2025. Thereafter, my lord, 2 notices was issued by the special officer building. Hearing was done, no inspection, nothing of that sort.
Premises number was wrong, no?
Yes, yes. Instead of 71, it was typed as 41. It was later on corrected by your lordship.
Asun, it is the allegation of the writ petitioner
তাতেই করে দাও।
who is for the state.
My advocate is appearing for the
I am for the Asansol Durgapur Development Authority.
my lord, please to fix it for hearing. I request your lordship to read out the order passed by Justice Sinha in this matter. Order dated 22nd January 2025. Entire thing will come up to lordship.
Order?
Then order dated 22nd January 2025. Then I will make myself. চরণ আছে নাকি চরণ 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 দা আছে ম্যাডাম চরণ দা আছে
So, Mr. Basu, your contention would be, I believe, that despite submission of comprehensive plan, your client were not were not made known about the fate of the said plan.
This is sum and substance.
This is the said and for way on, and therefore the order impugned
Should be citizen.
should be satisfied.
But what is the case? I am a lessee of 1999 years.
Report has been filed.
Report has been filed.
Let me check, sir, once.
Yes.
Report has been filed, sir. Yes, thank you very much.
I will come to page 27. The order of cancellation was passed on 8 December 2022. Page 27. There is a stipulation in the lease deed that you have to construct the building within 3 years.
Page number 27 you are referring.
This is the original order of cancellation.
Order under challenge.
No. This is the
Original, initial order.
that has been, I will come to later. Kindly come to the last part, one paragraph. Accordingly, after the narration of facts, accordingly, I, on behalf of the government of West Bengal, do hereby give you notice that as you have failed to construct the residential building on the said land as per terms and conditions of indenture of the said lease executed and registered on 25th April 2006, file number 2 Roman 4, the demised land will be resumed by the government of West Bengal on such and such date. What is the allegation? That you are unable to construct within the period of 3 years.
Yes.
That was subject matter of challenge before your lordship.
This order.
This order, not in this proceeding, earlier proceeding.
Oh, in an earlier round of litigation, it was under challenge.
Yes. Initial, this order was challenged before your lordship's court. Page 28 is the order passed by Justice Ghosh.
Yes, sir.
I request you also to, if possible, can I read this order? Everything will be called out from this. I have pleaded financial distress. I have.
Give me a
Well,
second.
it will be better. My lord, can I read?
Mr. Basu, will you please come to page number 29 once?
29.
1, 2, 3, 4, 5, 6 line from the top. Would it be 6 September 2022?
The authority issued a so-called notice upon the petitioner on 6 September 2022.
It should be 2022.
It was 2012 itself.
Oh, it's the initial one. This
Initially
is the
it was
initial one.
2012.
Yes.
Oh,
That has been given a go by,
acha.
not taken any steps.
I be Very good. You have been permitted to
Now, my lord,
submit a comprehensive representation.
Now, my lord, at this stage,
Yes, sir.
your lordship kindly come to page 130. This is the order dated 28 February 2023. Interesting. This is a compliance of the order of Justice Ghosh. Kindly come to the last portion of this order. Next page, 131.
Yes.
And whereas, my lord, kindly, I am reading with my lord.
Yes, sir.
Whereas, after considering the hardship faced by the concerned writ petitioners, like effect of demonetization resulting in financial crunch, along with pandemic occurred throughout the country on account of unprecedented COVID-19 virus, as being mentioned in the writ petition, comprehensive writ petition show also the views adopted by the Honorable Court was like consideration of the writ petitioner's submission before issuing the order for resumption of the land, for issuance of the notice, and accordingly opportunity of hearing. Next is very important. The writ petitioner is hereby directed to submit one comprehensive plan regarding utilization of the leasehold land within 1 week from the date of receipt of this order, failing which the order dated such and such will be given effect to on stricto sensu manner, and further deliberation will be made subject to receipt of the comprehensive plan as indicated herein above. So it, my lord, clearly said the earlier part condone. Consideration is the earlier part condone. You give a plan how you will utilize, and if you
Within
file
one,
it,
within one,
1 month. If
within
you
1 week.
if you file it, then only further consideration. So consequently, if you don't file, all your order will be executed. What do we have done? Well, kindly come to the next page. 132. And my lord will get for your lordship satisfaction, my lord, what we have said at page 133.
Yes, sir.
My lord, kindly see B. Actions before taking up the actual construction. What is the required to be formalities to be required? We have said. Then, my lord, kindly come to D. The required for construction of the premises, time required for construction. We have also said this plan was comprehensive plan was submitted.
What we intend to, we want to develop a commercial residential complex
Yes.
as per character of the land described in the list. Yes.
Mainly time is the, my lord, the concern.
Action
D.
before taking up the
The area of construction is a busy residential commercial place. Heavy traffic movement is therefore, but we will plan accordingly, and we will adopt a standard operational methodology to have a accident-free construction by maintaining the proper quality and within a proper identity.
You are reading from which portion?
D.
D for doctor.
134. So this is the comprehensive plan we have given as per their dictation.
Then
My lord, we give a reminder.
page number. There is no forwarding letter.
Yes, ordinary I have shown to you. 133, 132.
Oh. Enclosing one, yes.
Comprehensive plan.
Comprehensive plan. So
Subject.
page number 132 to 135 is the
Then, my lord, nothing has been done. We
submission of comprehensive plan.
Then, my lord, nothing has been, no steps has been taken. We give a reminder.
Give me a second. It was submitted on 6/3. 6/3. Yes, then what happens,
Then, my
sir?
lord, 136 is a reminder. No steps taken. You given a reminder.
Page number 136 is the reminder letter with reference to another plot number was
Next page 137 clause 8 is based some irrelevance, my lord. May I read for your lordship?
On others,
My lord,
right to
we
submit
enclose
another
again.
one comparison of directed to come accordingly the order sheet of the actor No further table.
We again give you a plan, copy of the plan has been annexed and
So 136 is a reminder letter.
remind. Then, my lord, the letter of hearing.
Reminder letter is dated 27/8/2024.
Then, my lord, the notice of hearing, 5th December 2024.
You are requested to appear on such and such days
We appear.
with comprehensive plan and all other elements. They're already submitted.
Submitted again, we went with that
Page number 130 is the notice.
notice. Well, then also again nothing was forthcoming. That's why we wrote a letter to them on 13th January 2025.
Page number 139.
139. That you have heard us, everything is there, but you have not done anything. Thereafter, my lord, the notice of termination comes.
Give me a second. I was directed to submit comprehensive report, which I did so by letter dated such and such. I again a letter to 27th August, enclosing various documents, comprehensive plan. In spite of several submissions, a hearing was conducted on 5th December. Very good, requesting me but till date I have not received any assurance or query from your good office to start the project. In absence of anyone, we cannot proceed. In absence of you, as to whether we can proceed with that. Give me and go ahead, proceed. Give me and go ahead. Very good, sir.
Then
Notice that it is a reminder letter.
reminder letter.
It is dated nil.
No, it is
13th
on
January.
13th January 2020.
Page 139. Reminder letter dated 13/1/25. Then what happens, sir?
Then, my lord, impugned order 142. My lord will find in vain that any consideration of my comprehensive plan which we have submitted. We are reiterating that we had violated clause 2, Roman 4. That's why.
Is there any whisper about the submission of comprehensive plan?
No, no. Whisper is there.
Where
Can
is
you
this?
come
Where it
to the
is?
next stage. Whereas an opportunity was being provided to you on for subsisting the reason for non-compliance with the DWs in pursuance of the hearing conducted such and such, the chief executive officer in accordance with the order of your lordship's court, and no satisfactory result has come out on perusal of the comprehensive plan submitted by the allotee in view of the fact that no extension of time is being allowed over any leasehold land by the state government.
No, is there any communication that the comprehensive plan as have been submitted by you is not acceptable? Therefore, you are hereby directed to show cause as to why.
This is the only order. This is the only order.
No,
After
sir.
comprehensive plan, this is the only order.
Very good. What is their contention in the report?
That you have not completed within 3 years. Is glaring on that only. After that, my lord, so many water flows. Your lordship's court condoned that part. They have condoned it and say give you a comprehensive plan, meaning thereby they want to give you some breathing time so that they can construct.
Very good, sir. Yes, what I have got to say.
One judgment your lordship want.
Yes.
That is reported in 2004. 2 Supreme Court cases 130.
2004, volume 2, SCC, page number, sir?
130.
130. Which paragraph according to is relevant, sir?
My lord, I'll give it to you. Hey. Just a minute. Kindly come to Kindly come to paragraph 43. Here it is called an agreement. In this case, it was a statutory force. Under the statute, this judgment has been rendered. Here also, under the statute, they have a right to resume. In terms of the provisions of the Act, the respondents are entitled to resumption of the land, resumption of the building, and forfeiture of the entire amount paid for deposited. Having regard to the extreme hardship which may be faced by the parties, the same shall not be ordinarily be resorted to. By proportionality, the doctrine of proportionality has been invoked here. By proportionality, it is meant that the question whether while regularizing exercising fundamental rights, the appropriate or least restrictive choice of measures has been made by the legislature or the administrator so as to achieve the object of the legislation or the purpose of the administrative order, as the case may be. Under the principle, the court will see that the legislature and the administrative authority maintain a proper balance between the adverse effects which the legislation or the administrative order may have on these rights, liberties, or interest of person, keeping in mind the purpose which they are intended to serve. Then, my lord, paragraph 19, if you will also kindly see, is also in the doctrine of proportionality. And last paragraph, which I relied, that is paragraph 57.
Paragraph?
57.
Paragraph 47 is required.
49.
No, I want to see paragraph 47.
47. 46 is required, 47 is also required. But this is on doctrine of proportionality.
Reasonableness.
Or say, what in the manner which you are, my lord, expressing. The principle adopted by Justice Sinha is doctrine of proportionality.
Then which paragraph, sir?
Then, my lord, kindly come to paragraph 49. Last 5 lines. In such a case, the administrative action in our country has to be tested on the principle of proportionality, just as is done in the case of main legislation. This is, in fact, is being done by the courts. Administrative action in India affecting the fundamental freedom has always been tested on the avail of the proportionality in the last 50 years, even though it has not been expressly stated in the principle that is applied in the proportionality principle. Then, my lord, so far our matter is concerned, factually, the court is saying, what is court saying? Paragraph 57. However, hasten to add that we do not intend to lay down law that statutory right conferring the right of the respondent should never be resorted to. Here it was a constitutional right, statutory right, here is an administrative right. We have merely laid down the principle, given some illustration where it may not be used. There cannot be any doubt whatsoever that if the intention of the allotee is dishonest or with an ill motive, and if the allotee does not make payment in terms of the allotment or the statute with a dishonest view or any dishonest motive, then section 8A, this resumption clause may be invoked. This is, my lord, doctrine of proportionality. Here, my lord, there is nothing dishonest like motive, action. Your lordship's quoted earlier occasion, that part condoned and accepted by them. Then
Let us hear them.
may I come back one matter.
Yes, sir. Yes.
But if reply something substantial, my lord, kindly allow.
This. Yes.
Firstly, in the earlier round of litigation, there was no condonation. It was recorded that in the year 2005, the allotment was made. 2006, lease was granted for a period of 3 years. In 2011, there was an extension on the prayer of the petitioners. In 2012, a notice was given to show cause that they never replied in 2022. And thereafter, a notice of resumption was granted. Recording all these things, the Honorable High Court granted a liberty to the petitioners to approach the authority with a fresh representation without expressing the mind on the materials and on the merits of the case. Coming to the second point, that once we had called them for a hearing and asked them to provide a comprehensive plan, whether we have condoned it or not. Coming to this point, the order clearly says
Based on the judgment passed by the Honorable High Court, we are only asking you to bring a comprehensive plan that is also based on the consideration by the authority. There was no unequivocal statement made there that it will be condoned. Secondly, whether there is any right of the petitioner or not. Admittedly, once they apply for any extension, they admit that, and also it was just like provide me an opportunity so that I can make the construction or not. There is no right that the petitioner is claiming before this Honorable High Court. It is only a legitimate expectation that the petitioner can claim based on our statement that you bring a comprehensive report. It can only be termed as a legitimate expectation, and once those I admit that that part that is written there, that considering the hardships, petitioner will use it.
Sir, your first contention is that in the earlier round of litigation, the delay was not condoned by the coordinate bench.
No, it was no expression of mine on
Simply
the
an opportunity was given to submit a comprehensive representation.
Lordship.
If I properly correctly understood.
And
Please listen to me.
Lordship.
Your contention is that while disposing the writ petition, the coordinate bench directed the writ petitioner to submit a comprehensive representation.
Lordship.
And while dealing with that comprehensive representation, you directed the writ petitioner to submit a comprehensive report, comprehensive plan rather. Comprehensive plan. Then what happened?
Then after the comprehensive plan was submitted,
yes,
there was a decision taken by the state government in the meantime that I have disclosed in my report.
Yes.
Lordship, it's at page number. It begins from page number 7 of the report, and the relevant portion is at page number 9.
Page number 9.
9. Because it's a public land.
Give me a second, sir. Let me come to your report. Page number 9.
Page number 9. Page number 9 is the relevant portion. It begins from page number 7.
Page number 7.
Page number 7 is it begins, and the relevant portion is at page number 9, the decision.
Very good. Yes. What do you want to say about that?
Lordship, here, this is passed by the Chief Secretary, Government of West Bengal, and we are a parastatal under the Urban Development Department, this ADDA.
Yes.
The decision here is, it was decided that in the context of resolution of meeting of the Committee of Secretaries of such and such, dated such and such, to the effect that resumption process would be started where the plots were still unutilized in violation of the lease conditions. Resumption process would be initiated by issuing a show cause notice. A status report on resumption process of land parcel would be prepared by the UDMA department, and the same would be placed in the next meeting of the committee. It was also decided that in dealing with the resumption cases, relevant provision of the model deed of L and LR and RR and R department, which has been approved by the cabinet, may be referred for taking necessary actions so far as those are not in contravention to the provision of the executed lease deeds. It was highlighted that for allotment of government land parcel, renewal of lease and for conversion from leasehold to freehold, current IGR valuation of land is not relevant.
No, what I'm on.
Lordship.
While considering the comprehensive representation, you have granted him to liberty to file a comprehensive plan.
Lordship.
Now, what I intend to know that after submission of comprehensive plan, have you made any communication with the writ petitioner stating inter alia that though I have permitted you to submit a comprehensive plan, but because of this letter we cannot consider, we have to initiate the process of resumption. Have you communicated that?
Lordship, after this decision was taken by the state government, this notice of determination was issued, and here itself it is written that no satisfactory result has come out on perusal of the comprehensive plan submitted by the allottee in view of the fact that no extension of time is being allowed over any leasehold land by the state government. It's in page number 143, the first paragraph. It was indicated there. Page number 143, the first paragraph deals with the comprehensive plan and states the reasons for not considering the comprehensive plan.
But prior to coming to a decision, you have not given any chance of hearing.
Chance of hearing was given. Comprehensive plan was submitted. Thereafter, while considering it, we have come with the direction of the state government.
Yes,
So our right to consider
now
ceases.
has come to a comprehensive investigation. No satisfactory result has been come. Thereafter, no show cause notice was given.
Show cause notice was initially given. They submitted a comprehensive plan. Now the question remains whether we have a right to consider it or not. After the state government's direction comes, we do not have any right to consider any other plan for extension once they have flouted the conditions of the lease. So there is no question of considering the comprehensive plan.
Yes, anything more?
Shiva, only as far as the law point is concerned, I'll realize that the petitioner, in order to approach a honorable court and the High Court under Article 226, has to show a legal right. Here, admittedly, they do not have any right under the lease because the lease period 3 years admittedly has remained. It lived its life. Now they can at the most claim legitimate expectation, doctrine of legitimate expectation. I'll rely on two judgments of the Honorable Supreme Court. And also, if I stretch my argument, though I'm not admitting it, it can at the most be promissory estoppel if this statements made in the order that you submit a comprehensive plan can at all be considered as a promise that it will be considered. It can at the most be considered as a promise and stops me from taking a different step. In case of legitimate expectation and promissory estoppel, if there is a public interest involved for protection of the larger public interest, then the petitioner cannot only on the basis of legitimate expectation and public interest and promissory estoppel claim any right under Article 226 because the greater public interest is involved herein and the state is free to change the policy decision if a greater public interest is involved. I'll rely on two judgments. Are they? This is reported in AIR 1994, Supreme Court 988.
AIR 1994, Supreme Court
988.
988.
Paragraph 36.
There is no page number.
May I take it out for you?
No paragraph number. No.
Paragraph number is there. It's paragraph 36. I'm so sorry for that.
Yes.
36 actually considers the legitimate expectation, and I'll rely on the next page after 36 begins. Is the mind of the court has been expressed. In the next page, it begins with if a denial of legitimate expectation.
Kindly please, sir.
If a denial of legitimate expectation in a given case amounts to denial of right guaranteed or is arbitrary, discriminatory, unfair or biased, gross abuse of power or violation of principle of natural justice, the same can be questioned on the well-known grounds attracting Article 14, but a claim based on mere legitimate expectation without anything more cannot ipso facto give a right to invoke these principles. It can be one of the grounds to consider, but the court must leave the veil and see whether the decision is violative of these principles, warning interference. It depends very much on the facts and recognized general principles of administrative law applicable to such facts and the concept of legitimate expectation, which is the latest recruit of a long list of concepts fashioned by the courts for the review of administrative action, must be restricted to the general legal limitations applicable and binding the manner of the future exercise of administrative power in a particular case. It follows that concept of legitimate expectation is not the key which unlocks the treasury of natural justice, and it ought not to unlock the gates which shuts the court out of review on the merits, particularly when the element of speculation and uncertainty is inherent in that very concept. So only a expectation based on something without support corroborated by any rights to be claimed subject to correction cannot be granted.
Anything more?
And the second judgment, if at all there is a promissory estoppel claimed by the petitioner, and in that case, if there is a change in the policy decision, then also if it is for the betterment of the larger good, that cannot be enforced. Kindly takes up this judgment. This is AIR 1996, Supreme Court 3461.
AIR 1996,
Supreme Court
3641.
3461.
3461.
I am relying on paragraph 3. May I read out?
Yes.
In the light of the above, policy question emerges whether whether the government is bound by previous policy or whether it can revise its policy in view of the change potential foreign markets and need for earning foreign exchange. It is true that in a given set of facts, the government may in appropriate case be bound by doctrine of promissory estoppel evolved in Union of India versus Indo-Afghan agencies. But the question revolves upon the validity of withdrawal of the previous policy, introduction of a new policy. The doctrine of legitimate expectation again requires to be angulated thus, whether it was revised by a policy in the public interest or the decision is made based upon any abuse of power. The power to lay policy by executive decision or by legislation includes power to withdraw the same, unless in the former case it is by malified exercise of power or the decision or action taken is in abuse of power. The doctrine of legitimate expectation plays no role when the appropriate authority is empowered to take a decision by an executive policy or under law. The court leaves the authority to decide its full range of choice within the executive of legislative power. In matters of economic policy, it is a settled law that the court gives a large leeway to the executive and legislature. Granting license for import or export is by executive legislature policy. Government may take a diverse factor for formulating policy for import or export, and this is not relevant. I rely on this portion of the judgment for this in support of my contention that this is a public land. It was allotted in favor of the petitioner. Our policy was that there is shortage of public land and it is provided at a very meager price compared to the current market price that is prevailing now. So, allottee, who is now a lessee, was a lessee, from 2006 to 2022 takes no steps at the cost of public funds and public land. Initially, it may have been a policy to ask for a comprehensive plan. We could have considered it whether it would have gone in the favor of the petitioner or against it. Now, once the policy decision has changed in for the benefit of the public good, now we have the subject to correction and with deepest humility, following these judgments, that the executive cannot be restrained from changing its policy. This is what I am submitting.
May I know your good name, sir?
Sharanyo Chatterjee.
Mr. Ganguly? What have you got to? Where is Mr. Ganguly? Oh. Yes, sir. You Mr. Sheikh, Ballal Sheikh. What have you got to say? You adopted the argument of Mr. Chatterjee? Take down.
Your Lordship, if I may just point out something.
Not required.
From the report, Your Lordship.
Listen to the order. Not required.
the comprehensive plan, not the representation plan. It's same mean.
Yes, yes.
Great.
Phonetics are same, that is why I'm right. ড্রাফট পাঠিও আমাকে দেখে নাও।
Number 4.
Which for the state?
Well, I've found. Quite I've found.
Where is the affidavit service, sir?
Right.
Is there any private respondents?
I got it. But these are only the state representatives.
Why nobody is appearing for the state? Be there as it may. Make your submission.
My lord, this case, my lord,
What is your prayer?
that's a consideration. By the minute, regarding the mutation,
Yes, what is your case, sir?
my lord, I had bought a plot of land of 2 kathas at Shivrampur.
At
Shivrampur.
Sibrampur.
Shivrampur. It is near Soshura, Kerala.
Yes.
And after I had bought the land, and I went for mutation.
With the which office?
The BNLR. And thereafter to the corporation. My lord, at page 26, my lord,
Just a minute, sir. Page 26.
lordship,
Give me a second. 2 কাঠা শালি জমি 8 ফুট প্রশস্ত কমন প্যাসেজের যাবতীয় ইজমেন্ট ও ব্যবহারিক সত্ত্বাত। It is in plot number 171 in মৌজাটা কোথায় রে বাবা? পড়ুই মৌজা. Yes. You purchased the land. Then what happened?
my lord, after it is near Mohestala, বর্তমান মহেশতলা. From page 22, your lordship will get. পাড়ুই মৌজার অন্তর্গত যাহা বর্তমান মহেশতলা মিউনিসিপ্যালিটি.
মৌজা পড়ুই municipality Mohestala. Yes, be there as in. What is your
Municipality, there is no agricultural land. Is there present, my lord?
be there as in? What is your
Now, my
problem?
lord, I went for mutation.
What is your application?
My application for mutation is, my lord, it is at page 29, 28 to 29, my lord. 2 pages, 20.
BLRO.
Lordship.
To go before the tribunal. To go before the tribunal. Inaction of the BLRO is subject to is the subject matter of jurisdiction of the tribunal. এই ওয়েস্ট বেঙ্গল ওইটা দাও তো কি বাবা, ওই ল্যান্ড রিফর্মস একটু, ল্যান্ড অ্যান্ড টেনেন্সি ট্রাইব্যুনাল। ঠিক আছে, এতেই হয়ে যাবে, এতেই হয়ে যাবে। থ্যাংক ইউ ভাই। আসুন, দি এফিডেভিট অফ সার্ভিস
I appear for the state, my lord.
Well, here the petitioner.
Give me a second, madam.
I am told by Mr. Banerjee that my client West Bengal Mineral Development is a party in the present proceeding, but copy has not been served.
Then serve copy.
And I have gone through the prayer. There are two fold of prayer. So far first prayer is concerned, I will not stand in the way. He wants early disposal of the appeal, which is pending before the divisional commissioner. So far as the second prayer is concerned, in the meantime, that has already been, lease has been granted. He prayed for cancellation of the lordship to that effect. If that my learned friend insists for that prayer, I'll file an opposition.
You want to press the second prayer or disposal of the appeal?
Second prayer also.
Second prayer also. Then serve.
The lordship kindly direct her to serve.
You are respondent number 3, no?
3.
At the very outset, Mr. Saha, learned advocate, appearing on behalf.
My lord, Didi, six.
Service regarding the service of the private respondent may be taken.
Your lordship, I'm praying for.
Have has been affected?
Already received.
তাহলে নিয়ে নাও the affidavit দুটো লাইন অ্যাড করে নাও the affidavit of দেখি একবার দেখে নিতাম the affidavit of item number 6, sir.
I appear for the petitioner, my lord.
I'm praying for accommodation on behalf
For
of
the
learned
status.
The
advocate.
private
Praying for the-
respondent has a private
He is not ill today, so praying for not today.
the private respondent has no role to play, my lord. If my lord kindly sees last day's order, my lord.
No, Mr. Biswas is singing in.
Somodi
No,
please.
before he prays for adjournment, my
That is
lord.
why I'm asking for.
A minute. The last occasion, my lord directed the state.
Only not this week. Only not this week.
Just 2 minutes, my lord. Because the state has already filed the report, my lord, has served us.
Yeah, Mr. Biswas is indisposed of, not this week.
Let the report be accepted.
Very good. I will consider that report.
Report to file for
You are submitting a report.
that report be accepted.
I thought you are doing not this week.
Let I appeal for the petitioner. So this is the copy of affidavit of service. Let two plots of land.
Give me a second, sir. Is there any private respondent? All are state? I am. Give me a second. Yes.
Two plots of land within the area of Rajpur Sunarpur municipality. I have purchased from the erstwhile landowners. My name got mutated. I paid taxes. Now, my lord, this plot of land was a subject matter of acquisition in the year 2010.
What are the plots of land?
RS Dag number 112 and 13. The schedule of land at Millet at your lordship will find at page 35, bottom. Schedule. Is and parcel of Danga land measuring about more or less 3 kata such and such. Part of RS Dag number 112. In the next page.
Come to paragraph page number 5 first.
5.
Page number 5.
Yes.
Is the absolute owner of such and such
4
foot decimal of land in RS plot number 1112 and pastu land measuring 5 decimal in RS plot number 130. Very good, sir. So 112 and 113. Now these are 112 and 113 were subject matter of
land acquisition.
yes.
The year 2010. Subsequently, physical possession was taken of this land for the purpose of construction of link road of Godiya along with Adigonga. Page 54, kindly come.
Page 54.
54.
Declaration.
Yes. Notification.
Under section 6 of Act 1 of 1894.
This to satisfy not being a
100. Your plot number is 112 and 13.
Schedule.
RS.
Yes.
RS plot number 112 is there.
12. Corresponding to LR plot number. Kindly see. Last 113. Last number of the same line.
Corresponding plot number 113. Yes, sir.
Hereafter, physical possession was taken.
Yes.
For the construction of link road of Godiya Baripur Adigonga. Thereafter, your lordship will kindly come at page 60.
60.
60. Physical possession was taken. Notification. In terms of page 54.
54 is the
Notification.
Declaration notification.
Notification.
Page number 60 is what?
Physical possession. Taking physical possession.
No, it's an information.
No. Page 60. 60.
Letter dated 1/8/2018.
Letter dated 1/8/2018 is page 58.
কি বলছে বাবা আমি তো বুঝতে পারছি না হোয়াট ইজ দি পেজ নাম্বার স্যার
Page 60. 60.
আরে বাবা পেজ নাম্বার 60 কোথায় এ দেখানো কি লোক মা মুশকিল পেজ নিয়েছেন গুলো উল্টো পাল্টা পাকায়
It differs from my page.
Then how do I do that? What type of pagination you are doing? Now,
Page 62.
Page 62.
Physical possession was taken.
Give me a second. Sir, I'm not so sharp like you. How do I understand that your 60 means
I am
my
tendering
60?
apologies. My responsibility. My clerk has done the mistake. Milord, I am tendering apologies.
Yes, certificate of possession.
Thereafter, Milord,
Certificate of possession of land made over to the parties on whose behalf it has been acquired.
physical possession taken. Thereafter, at page 56. Milord, kindly come once.
Page number 62. Does it bear any plot number, sir?
Plot number, Milord? No. In terms of the earlier notification, plot number is mentioned at page 54. In terms of that notification, the physical possession was taken.
By the respondent authority.
Yes, yes. Thereafter, Milord, page 66, kindly come once. Page 66, 56, sorry,
56.
56. Answer P5.
Yes. P4 or P5?
P5.
Then it is page number 58 in my case. Memo dated 24/6/2025.
That land,
Memo dated 24/6.
yes, 24/6.
Just a minute. What is that?
The land which was acquired was relinquished. Box. Milord, status of the land. Kindly see the box. Last column. Not acquired for KMDA project. RS Dag number 112 and 113.
But there it is RS Dag number 112 and LR plot number 130. So what do you want?
Milord, RS Dag number 112.
Not
and
required.
113. This plot of land, Milord.
So have you made any representation?
That was, Milord, no. I purchased the land in 2018 October.
Post acquisition.
Post acquisition. During that time, in terms of this notification, Milord, the land was relinquished.
When the deed of registered deed of conveyance was executed?
Milord, October 26, 2018. October 26, 2018. Page number 27.
Mm-hmm. 26th October.
Yes.
And it was registered on 29th October.
Yes. And before that, land was relinquished from the acquisition process.
This you got by virtue of a
RTI.
RTI.
By the erstwhile landowner.
Just a minute, sir. Page number 58 is the dated 24/6/2015. Yes. And your deed of conveyance was registered on
26th of October 2018
executed on 26/10
and registered on 29th.
Registered on 29/10/2018. Yes.
After my purchase, Milord, I came to know from the reliable source that
But
land
it is not required for KMDA. So had it been relinquished,
relinquished.
wherefrom will get that?
Milord,
It is an internal
Continue.
communication
not
which
acquired.
says that it was not.
Acquired.
No, sir. Acquisition acquisition comes to a acquisition becomes complete as soon as the declaration is published.
My lord, may I give it a
Give it the report. Yes, Mr. Dev, what is your content?
My lord, my contention is that, my lord, 4, 6 and everything was done, my lord. And my lord, money was also given to the owners, my lord, that.
Milord, without giving me any intimation.
But the
any-
declaration of the award was made. Declaration award made award number
Possession was delivered on author in the year 2012, KMDA.
Then post acquisition purchaser.
And after that, my lord, all the possession certificate was also annexed. My lord, award list, my lord, is also there. Everything is there, my lord.
Very good. Ashun.
This achievement, Milord, I have to file exception to this report.
What exception you will file?
Without giving me any opportunity of hearing, without giving me any notice, from where the award comes. 2018, they are saying that not award. August. The document which is appended at page 60, 1st of August 2018.
Not required. Ashun. The
I am for the state.
They.
সেদিন যেটা
No, no. The affidavit of service, my lord.
Yes.
This pertains to grant of.
Give me a second, sir. Yes, sir.
Well, this pertains to grant of mining lease for Blackstone mining. Well, the process was started in 2011. The petitioner applied for mining lease for Blackstone mining as per 2002 rules. At that time, 2002 rules was prevalent. That was considered. The grant was made on 7th of March 2013. Kindly take page 36.
Hey, 2016 rules to work on minor minerals. 2016 minor minerals to start. Big number, sir?
36. 12 rules. Is it telling?
Yes.
7th March
7th March 2013.
2013. These are the grant. Kindly take the bottom of that page, clause D.
Yes, sir.
The draft mining list shall be in the model form prescribed in the West Bengal Minor Mineral Rules 2002, subject to incorporation thereon, clause 3A, 3B of Part 7 in the deed of mining lease. This grant was as per 2002 rules.
Yes, sir.
I'll come to that provision. I'll show all provisions.
Very good.
After the certain formalities were required, the mining plan has to be approved. Ultimately, lease deed was registered on 2nd of May 2019. Kindly take page 46, it starts.
It was executed on
2nd May 2019. Executed and registered.
It was for 5 years.
5 years. Under 2002 rules, it was for 5 years. P4, annexure P4. This was also this was executed in form E under minor mineral rules. Kindly take the bottom of that page. Top of that page. Form E, see Rule 24(1) of the West Bengal Minor Mineral Rules 2002.
Yes.
There is a clause of renewal for one-time renewal. Clause 3, Part 8, page 62. One time renewal was allowed, but has you also got it? Page 62.
Which portion, sir?
The clause 3.
Clause 3.
Yes.
Mining shall be.
The mining lease shall be renewable for one period, not exceeding the period specified in sub-rule 1 of Rule 12 at the option of the lessee. That's my option.
Yes, sir.
Provided, however, that the state government may refuse to renew a mining lease over the whole or part of the area covered in the order for which renewal is paid for. Now, other condition is if the lessee is desirous of taking renewed lease of the premises hereby demised or any part or parts of them for further term from the expiration of the term hereby granted and is otherwise eligible, they shall, prior to the expiration of the last mentioned term, give to the state government 6 calendar months previous notice in writing and shall pay rents and rates, etc.
So 6 months prior notice is mandatory.
Mandatory. We applied for renewal. I'm just, so where the renewal is concerned, I'm placing page 15.
7. But before your lordship goes to 157, my lord, I just place before your lordship the 2002 rules.
Yes, sir.
Probably your lordship's books, I don't know whether it contains the 2002 rules.
Two 2002 rules. What is the name, sir?
West Bengal Minor Mineral Rules 2002.
No, it is not here.
Yes. May I give supply a copy?
এই আমাদের দাও ওগুলো দিচ্ছেন দাও ওটা
এটা আমারটা।
আমাদের 2002 রুলস আছে এখানে
The old books it is there. But,
be that as West Bengal minor minerals rules 2002, sir.
yes. Now kindly, if you also kindly take rule 12 of that rules. It is at page 870.
Give me a second, sir. Rule 12.
Yes.
হ্যাঁ আমি তো বলছি আছে বার করুন তো, যদি পারেন টাকার তো কত বসে পড়ুন বসে পড়ুন yes renewal of mining lease.
Yes, but prior to that, I'll take rule 11 first, 11(1), the period for which a mining lease may be granted shall not be more than 5 years. That will also got it 11(1). Rule 11(1). Same page. That is the period of lease.
Shall not be more than 5 years.
More than 5 years. And for larger area, it may extend to 30 years. We are not concerned. Our lease was for a period of 5 years. Then 12, and an application for renewal of mining lease shall be made to the state government or to an officer duly authorized by the state government in this behalf, informed at least 6 months before the date on which the lease is due to expire, but not before 9 months from such date of expiry through chief mining officer. So the same as per the lease terms I had shown you.
Have they rejected on account of the promulgation of new rules?
But prior to that, there is an order I will show. But kindly take 12(6), my lord. But first, 12(6).
Yes.
But if an application for renewal of mining lease submitted to the receiving authority within the time is preferred to its approval is not disposed of before the date of expiry of the period of the lease shall be deemed to have been extended for a further period of 6 months or period ending with the date of receipt of the orders of the state government, whichever is shorter.
If an application for renewal of minor lease submitted to the receiving authority within the time is not disposed of or before the date of expiry of the lease, the period of that lease shall be deemed to have been extended for a further period of. It will be extended
Automatic.
for 6 months.
Yes. Now
when you have submitted the
yes, application was made, my lord, 158, 30th October 2023.
Give the wait. Application for
renewal.
Submitted on
30th October 2023.
30th October 2023. 23.
Yes, it was going to expire in May 24, 6 months prior.
Then when these rules have come?
These rules come in 2016.
29 July 2016.
16.
And the lease deed was executed.
19.
So lease deed was executed in terms of 2016 rules must be.
2002 rules, because the grant was in 2013. I had shown the lease deed also. It was also under 2002 rules.
Very good.
And
Now, sir,
they had accepted it. I'll show.
very good, very good. So far, execution of lease of this was no doubt.
No doubt. Now, kindly take, my lord, since they have not considered, we came before this court and an order was passed on 22nd of May 2024. But kindly take page 184.
But it is barred under section 61.
No, 62(1). There is a saving clause.
No, 62 is to be read with 61.
There is a saving clause.
Read 61.
All application mailing these of minor minerals 12 February for releasing received prior to the giving effect to this rule, irrespective of its duration or pendency, shall become ineligible. Provided that if the application has been issued for
No, sir. Be slow. All applications for mining lease of minor minerals, including the reclassified minor minerals, received prior to giving effect of these rules, irrespective of its duration or pendency, shall become ineligible. Now we have submitted the renewal on. No, I will do that. I will do that. I will come to that. You have submitted on 30th October 2023. That is that during the subsistence of the when the rules of 2016 has come into force. Anyway.
Provided, kindly take 61 proviso.
Yes.
Provided that if the applicant has been issued with a grant order or letter of intent or any other government order requiring the alteration of then his mining lease application may be considered after due compliance.
So your grant order or LOI was
13.
Sir, try to listen, sir. I may be wrong.
Yes.
If I'm wrong, please correct me. Your initial grant order or LOI was issued in terms of the lease deed?
No, in terms of rules, lease deed was first for the
very good. In terms of the in respect of the lease which was executed on 2/5/2019. So far as your claim for extension of 1 year, any GOI or any GO or any LOI was issued.
I don't get it. Malad, this provides
So far as your in respect of your application for renewal of lease for 1 year, any government order or LOI was issued? No.
For 5 years.
1 year. Grant order was issued for 5 years.
13.
It has prior to coming to its end, you have submitted your application for renewal.
No. Grant order is in 2013. Pursuant to the grant, my lease deed was executed in 2019.
I understand, sir.
And the lease deed provides.
But in respect of the extended period of lease, which in respect of the proposed extended period of lease, any grant order or LOI has been issued? No.
No, that is.
Then how do you come? I will get the benefit of these provisions.
No, your lordship had said the 61 bars my lease. Your lordship has said 61, first 61, debarred me from getting the lease of 2016 rules.
I say, in my understanding, rules 61 of the rules 2016 bars grant of extension of lease on account of absence of any GO, that is grant order or LOI. That I intend to say.
No, 61 covers for any for grant of first lease.
Sir, kindly place then proviso.
Yes, kindly take all applications for mining lease. Kindly take all applications for mining lease, of minor minerals, including reclassified minor minerals by SO number such and such, received prior to the giving effect of these rules, irrespective of its durations of pendency, shall become ineligible. So if there was no grant, any applications made prior to July, prior to 2015 would not have.
So it is not applicable in your case.
No, it is not application because of the proviso. Proviso
Proviso,
protected my application.
What proviso says, sir?
Proviso said that if the applicant has been issued a grant order or letter of intent or any other requiring the alteration of the applicant's position, then his mining lease applications may be considered after due complications of the all necessary conditions.
My question is that for the extended period, or rather for the proposed extended period, any grant order or LOI has been issued or not? That is not required.
Your Lordship is not. This is applicable for the initial grant, for the initial lease.
And what is the provision for extension?
Renewal. That I had shown for rule 12.1 and then 62. Kindly take the repeal.
Yes.
The original mineral rules is hereby repealed. Notwithstanding such repeal, anything done, any action taken, or any prosecution started under this shall be deemed to have been validly done, taken, or started as the case may be under the corresponding provisions of these rules. Then kindly take section 6 of the General Clauses Act. What is the effect of saving? Right, 6C. I have.
Yes.
Where these act or any central act or regulations made after the commencement of this act repeals any enactment hitherto made or unless a different intention appears, the repeal shall not. Alright, I am not A, B, C. Kindly see C. Affect any right, privilege, obligations, or liability acquired or accrued or incurred under any enactment so repealed. Now, my initial grant of lease was under 2002 rules. And 2002 rules, Rule 12, I had shown you losses, protected my renewal for one period. And it also, 12.6 says that if in the event the application was not considered before the expiry, there will be automatic grant of 6 months.
2016 rules does not provide any renewal. It has to be made by auction.
It has to be made by auctions, but
I believe that defense has been taken by the state.
May I just...
There is no any renewal clause for that reason. There is also no renewal clause.
Or which?
In
my lease deed, there was a renewal clause specific. This lease was made under 2002 rules.
My lord, I want to file the affidavit in opposition, my lord. As because, my lord, our officer has requested us to.
Oh, then why are you wasting my time?
Yes, my lord.
Only one. Kindly take only, I will not show, 184 kindly come. Page 184.
No, let them affidavit in opposition.
Yes, in the meantime, on June, my extended 6 months period has also expired. There are hundreds of persons.
If there be so, what is the scope of passing any interim order, sir?
Only scope is, let them do not proceed for auction for this leasehold area. Let it be heard any day because there is no disputed questions of fact involved. This is absolutely on the question of law. The impugned order also says so much. Kindly just bear me for a moment, 184. This was the order passed by the Honorable Justice Shubhra Ghosh. Now, what kindly take the learned counsel for the petitioner has placed reliance on clause 12.6 of the West Bengal Mineral Resources hearsay and has submitted that since his application for renewal of mining lease made within the stipulated time frame was not disposed of before the date of expiry, the period of lease is required to be extended. Lease expired on May 1. It is submitted on behalf of the respondent. The application filed by the petitioner for extension of lease was sent to the Deputy Secretary to the Government of West Bengal Department by the additional district magistrate such and such. There is no document on record which suggests that the application was considered and disposed of. In view of the above, this court is inclined to hold that the petitioner is entitled to extension of lease for a period of 6 months from May 1, 2024 in terms of clause 12.6 of the 2002 rules, meaning thereby the lease shall be valid till November 1, 2024. Matlab, these directions was complied with. Matlab, kindly take page, matlab, initially not done, then no appeal has been preferred against this order. Then kindly take 30th September 2024 order of the government, page 186. 186 is the communications, 187 is the order. I don't think whether it is written.
It is against you, in favor of you, no.
In my favor. They've accepted the 12.6 I am entitled to. If
Then why have filed the writ petition?
The renewal, this was the temporary extension for 6 months.
Huh?
This was for temporary extension because they did not dispose of my application. The automatic extension of
Give me a second, sir. So you have already got 6 months extension.
6 months extension I got, but the rejection was made that I am not entitled for renewal in view of section 62, rule 62 of the 2016 rules. And I'll show one order.
Oh, show me the order. Show me the order.
Yes, kindly take impugned order, that is passed on 209. We had submitted, there was a hearing was given, why we submitted written submission also, took all this as point. 209 it starts. In fact, in a penalty proceeding, they said the penalty, there was no provisions of penalty under 2016 rules. They said no, 2002 rules will be applicable. And now, while considering the
where is, show me the order under challenge, sir.
That is 2000, page 209.
210.
209.
Which order is under challenge?
Yes. Now, relevant portions kindly straight away come to
25/2019.
2000, page 212. Section 6 was not considered.
7th May.
202.
212, my lord. Sorry.
Yes, sir.
But it starts.
No, let us read from page number
A.
211. Sir.
6, paragraph 6, 211.
Yes, sir. Read from there.
Yes. The lease deed in the instant case was executed after the West Bengal Mine and Mineral Concession Rules 2016 came into force.
Yes.
The said rules expressly repealed the West Bengal Mine and the overlook that the lease was executed under 2002 rules. However, provided in case of LOI was granted prior to the coming into force of 2000, then the mining lease could be considered by the state government. The lease in the instant matter was allowed LOI in 2013, and his application was considered by the state government in the Department of Industry Enterprise in terms of Rule 61 of 2000, and subsequently lease deed was executed in the year 2018. That is the wrong mentioning. It should be 2019. In my opinion, this action of the state government in granting my execution does not create any right in favor of the lessee for a further extension of lease upon expiry of the original lease. From a plain reading of such and such, it can be logically inferred that while intending the lessee who had granted LOI prior to the coming into force of 2016 rules could be considered for grant of lease under 61 of the no such express condition has been put forward. Further, Rule 62 to validates only those acts which have been validly done, taken or started under 2002 rules at the time of enactment. The prior date for renewal is not being initiated at the time of enactment of 2016 rules. Effective date, it does not cover. It is thus not covered under Rule 62(2) of in view of this. I am of the opinion the prayer of the rejected.
So what is the wrong? The absolutely justified order.
But I am entitled to one
The
renewal.
grant order was issued for 5 years, and on the basis of such, lease deed was executed. Now I understand your contention that your lease deed contains a renewal clause. Now in the meantime, the rule has been changed. 2002 rules have been abolished, 2016 rules have been placed. Now 61 says regarding the all pending applications except where LOI or GO has been issued will be invalid. I want to know, so far as on account of your prayer for extension of lease, any government or any grant order or LOI has been issued. If it is not done, it will not come.
The grant order, the question of issuance of the grant order after 2015 doesn't arise. That is that 61 pertains to fresh new lease, not for renewal.
Understand, sir?
Not for renewal.
Initial grant order was for how many years?
5 years.
5 years.
With a covenant of renewal of another 5 years.
In the meantime, the rule has changed. In the meantime, the rule has become.
But the lease deed contains that clause, and the
I
rule also
understand your
contains the
contention,
clause.
sir.
Rule also contains the clause.
Sir, I understand your contention. Initially, grant order was issued for 5 years. Pursuant to that order, lease deed was executed and registered. Am I correct, sir? That lease deed, according to you, not according to, is admittedly contains a renewal clause. That renewal clause also says that you have to submit an application between such and such date. That renewal clause also says that if that application is not disposed of, it will be deemed to have been renewed. Am I correct, sir? I believe up to this we have got no difference.
No dispute.
What I am on, that in the meantime the 2016 rule has come. 2002 rules have been abolished. Now 2016 rules, 61 says that all pending application under the previous rules will be, irrespective of duration, will be deemed to have been cancelled, provided if the appellant has been issued a grant order, letter of intent, or any other requiring alteration of applicant's position, then is binding application. I intend to know what materials are there before you to attract this provision in your favor. Proviso position.
Proviso, my lord, in my humble submissions, my lord, as far as my reading is concerned, my lord, 61 relates to the first grant, not for renewal. Renewal is covered by the covenant contained in the lease deed, read with Rule 12. Now that covenant contained in the lease deed, my lord, that survives.
No,
That's
sir,
my right
sir,
accrued.
Sorry.
My lord, that was upheld by this, my lord, court.
That is for an extension, makeshift arrangement. Ashu.
My lord, may I just show two judgments also, my lord? Since your lordship is dealing with the case finally, my lord, section 6, your lordship need to consider section 6C, because that there is no express, my lord, contrary intentions in the rule.
Section 6, obviously I consider. That is with regard to the repealing. But section 61 proviso is very clear.
61, my lord, this is a grant for grant of new lease, but not for renewal. Renewal was there.
I understand your concern.
Now kindly take, my lord, one judgment, 2004. What is the effect of renewal clause contained in the lease deed? Now it's a contract between the parties.
Their judgment is relating to 2016 rules, section 61.
No, this is a lease. My lord, as soon as the lease is executed, my lord, the lease governs the field.
Sir, try to understand, sir. Definitely lease deed govern. Had 2016 is not in vogue, I could have understood there is a genuine ground for your contention. But 61 proviso is a clear bar.
61, my lord, relates to the first time grant, not for renewal.
Take down, very good.
My lord, kindly take.
No, sir. No, not required.
Kindly consider this.
Not required, sir.
For my satisfaction.
Sir, I don't require this.
For my satisfaction.
No, sir. Not required, sir. Not required. If it is related to 61 and 62, I could have considered. And if it is only limited to General Causes Act, don't require.
No, I'm not. This is related to the terms of a renewal in the lease deed.
Sir,
regarding draft.
I fully endorse the submission as made by you. But this court is of the view that you are not going to get any benefit under the proviso of Rule 61. That I am simply.
My lord, my grant came in 2019.
No, sir,
My lord, I got the renewal
Let
clause in
me pass.
2019.
Let me pass my order.
How this 2016 or 61
Yeah.
applies in my case?
Very good, sir. I shall explain in my order. Ashun.
Yes, my lord. 40. Yes, my lord. Yes, yes. Yes.
Take down. The parties are not represented. Same order. Date একবার দেখে নেবে last order.
Whatever I was responded. We have filed our email and for the
45.
My lord, I am appearing for
has
the,
been exchanged, my lord, in this matter.
my lord, I am for the petitioner, my lord. Mr. Prantik was appearing for the petitioner. He was to conduct the hearing today. He left court in a hurry because his mother was hospitalized. This only, my lord, accommodation for
Ashu.
this week, my lord.
On behalf of the read prison and accommodation.
Number 41. I was running from that building.
41.
Lordship,
I passed order.
Lordship, running.
No, I cannot recall. Principally, I never recall. I don't request me. Make application, I shall consider.
Number 49.
49 I am for the petitioner.
Right.
Matter I have mentioned before your lordships. This is an application for recalling of the order dated 12 June 2025. On the date when the matter is called on, I was absent due to my fever, and my senior Mr. Bikash Ranjan Bhattacharya, senior advocate, also out of station. Kindly see the order itself, and I filed an application for recalling and preponing the date of hearing. Your lordship was pleased to post the matter.
When the matter was dismissed, sir.
No, not dismissed.
Then?
Your lordship was pleased to fix the matter on September.
Oh,
Yes, I mentioned the matter before your lordship, day before yesterday.
Since none appeared.
Page 11, page 11 of the application, page 11. No, my junior was there.
Oh, chilo.
They took time. Hey, yes,
Oh, adjournment was prayed for, I think.
yes. Rahul Dev Goenka, my junior, was present.
Matter is otherwise ready, Lordship.
Page 11.
Fix any day. I don't oppose this.
Can 4 of 2025?
Yes, we have urgency. I shall.
আগে 2 p.m. 59. Who's for the petition?
I am for the petition.
Readings are complete.
My lord. Pleadings are complete.
Mr. Saha, in which matter you are appearing?
Day before yesterday, I made matter private side. That side in matter will appear on the day in execution of the day at 2 p.m.
But is another heading special peace matter?
Only appear.
Who is for this state?
That's Mr. A.B. Mahaprasad.
এইটা তো এক্সটেনশন অফ ইন্ট্রি অর্ডার হবে রে ভাই, এ তো মহা মুশকিল।
One of my application is pending. I have paid for an application for addition of the body.
Can 13 hour?
Addition of body.
And your extension of entry order? You have filed any application?
I have by June, after 30th June, entry order was.
Mr. Pan, give me a second.
Well,
I'll take up their payment first. দেখি 46 টা দাও তো একবার। বোর্ডে শো করুন। টা দিন। রঞ্জিত মন্ডল।
Yes.
আচ্ছা।
I had initially extended the entry order on 20th March 2025. Up to 30th June 2025.
By which order, sir?
20th March 2025.
Customers. Now that's the time by. So it is till the end of June 2025.
Yes.
আসুন। Who is for the state? Oh, তাহলে
আমার সাহস নেই তোকে আটকানো
report submitted or affidavit in opposition file? What?
Report.
Huh?
A report submitted. I have taken the exception to this.
Reportটা কই গো?
An opposition.
Affidavit in opposition has been filed.
Opposition filed. Reply. I have
ছিনে
used
বেরিয়ে যাচ্ছে রে ভাই। You filed a reply.
my lord.
Where is your reply?
Reply must be in the file because time to time the matter has been interim order has been extended.
No, where is your reply? That I intend to know.
No, no.
Let me check, sir. Let me
My
check.
lord.
Yes, it is there.
My lord. My lord,
It is a land acquisition matter.
not land acquisition. This is against the issuance of a so cause notice issued by the additional district magistrate interior, my lord, describing me as a trespasser in respect of the land in question on the alleged plea of
Sir, just a minute, sir. এটা আবার supplementary affidavit বলছে কেন রে বাবা?
supplementary affidavit. ওটা তো আরেকটা মামলায় ছিল। In another matter, your lordship was kind enough to grant me a leave to file a supplementary affidavit annexing one document which I got by way of an RTI. মনে করে নাকি?
কি করলেন বাবু? এটা কি ব্যাপার হলো আমি তো বুঝতে পারছি না। সাপ্লিমেন্টারি এফিডেভিট বলছে এইখানটায়, অথচ ব্যাক সিটে লেখা আছে এফিডেভিট অপোজিশন, প্রিয়ব্রত বটব্যাল। স্যার, ইউ হ্যাভ ফাইল ইউর এফিডেভিট অপোজিশন আর সাপ্লিমেন্টারি এফিডেভিট?
No, supplementary affidavit filed by me and against that we have filed an opposition.
হ্যাঁ?
The supplementary affidavit. দিয়েছো ওরা কখন চেক করো তো। না ভুল হয়েছে তোদের।
কি হচ্ছে আমি তো দেখতে পাচ্ছি না।
দেখে নেবো দেখে।
অপোজিশন তো আমরা দিয়েছি।
কিষান এম আগরওয়াল, কিষান এম আগরওয়াল।
মানে অপোজিশন মাইনর ফাইল।
হ্যাঁ, opposition আছে।
অপোজিশন আছে। সাবমিশন নেই।
এটা কি এগুলো ওকে দেখো, আমি তো বুঝতে পারছি না বাবা, এটা কি লিখেছেন উনি। এই পেজ নাম্বার 2টা আমি ভাঁজ করে দিচ্ছি। হু ইজ বিশান এম আগরওয়াল?
Yes, madam, they are the petitioners before your lordship.
ও,
They are the petitioners.
এটা সাপ্লিমেন্টারি এফিডেভিট। আচ্ছা,
এটা কি?
চন্ডিদার কেস।
ইয়েস ইয়েস ইয়েস, সরি।
না পরেরটা।
চন্ডিদার দিল তোমার দিল।
না মালার
আপনারা না এটা আগে এইটা একটু খোলার ব্যবস্থা করা যাবে? এটা একটু খোলার ব্যবস্থা করা যাবে? ছিঁড়ে যাচ্ছে, এইটাকে একটু খুলে ব্যবস্থা করে দিন আপনি। কেটে দিন, আপাতত কেটে দিন। নিয়ে ওটাকে সেলাই টেলাই বা স্টিচ ফিচ করে দিচ্ছে, স্টেপল মেরে দিন ওইটাকে। কাটুন। হ্যাঁ, ওটা ছিঁড়ে গেছে দেখুন, ওই তলার অ্যানেক্সচার গুলো। না, হারিয়ে যাবে, একটা স্টেপল করে দিন না। হ্যাঁ, গুড। Dinamo. Yes, Mr. Pan.
Yes. My lord, the instant writ petition is against the issuance of a so-called notice, whereby I was directed to, my lord, vacate the premises in question, vacate the land in question, describing me that I am unauthorizedly occupying the said land, treating that land as a vested. Now, the fact of the case is this, my lord, that I purchased this land, my lord, from the erstwhile owner, and my lord, on my lord 25th of March 2013.
Yes.
Who was the, my lord, the recorded owner after initiation of a proceeding for vesting under the West Bengal Estate Acquisition Act. I was allowed to retain, my predecessor, my vendor was allowed to retain that land. I purchased the land, a portion of the land from him. Now, my name was recorded in the relevant record of right, as well as in the assessment roll of the Kolkata Municipal Corporation. And I am paying the rent and or taxes, whatever it may be the term, the Lord, I am regularly paying that. Since the immediately after execution of this sale deed, I was put into possession in respect of the land in question.
Yes.
Then, my lord, when this notice came to me, before, sorry, my lord, before I purchased this land in the year 2013, through RTI, my lord, I shot.
You said you purchased it 2016?
2013.
25th March 2016 or 13?
No, 25th March 2013.
Very good.
And 2011, I sought for certain information from the authority concerned about the status of the land. In reply to that, to RTI, by a letter dated 4th of April 2011, the District Revelation Officer, South 24 Parganas, informed me that no colony is situated over the plot number 640 Mauja Nonadanga, PS Tiljola, District South 24 Parganas, and the plot is not under the physical possession of this office.
Page number?
This is, my lord, memo dated at
page
number 112 of the writ petition. Lord, why I am saying this?
Give me a second, sir. Yes. But this letter is addressed to one Purnendu Datta?
Yes, my lord, he was my agent because before this is a before purchase. So on the basis of this letter, I was satisfied with this. Then, my lord, I purchased this land. Now fact remains this, my lord, that my predecessor in interest was in possession, and after that I was put into possession because, my lord, your lordship knows for the purpose of mutating my name in the relevant record of right under the West Bengal Land Reforms Act, before recording my name, an inquiry was held. That is the procedure. After inquiry, two things are being done. One is, my lord, the genuinity and the legality and the other notices, as well as the who is in possession of the land in question. So on the basis of that, my name was recorded, followed by corporation recording, municipal corporation recording.
Physical verification was done.
Physical verification was done because my lord, I tell you, lordship, why I was in possession. Otherwise, I would not have been termed as unauthorizedly you are occupant. Meaning they were otherwise, my lord, I am in possession, either illegally or legally. And my name has been recorded and the state government has accepted the rent from me.
Acceptance of rent does not create any title.
My lord, I was also impression like that, but your lordships, our court held this. That moment, my lord, rent is being accepted, then I am a tenant, direct tenant under the state. Otherwise. So in any event, my lord, I cannot be said to be the unauthorized one. Apart from this.
No, what is if you say that you have purchased the land?
Purchased the land. Now
how will become a tenant?
No, kindly see. Now, then, my lord, when I inquired about this notice, why I have been said unauthorizedly, then I got the information from the office of the collector. The land in question,
the Thika land,
was acquired under the West Bengal Land Development and Planning Act. There was a section 4 notification, followed by section 6, and award declared. So whatever submission I have.
So you have not made a proper searching to the purchase.
No, my lord. If I can satisfy your lordship that on the date of my purchase, the land was not vested with the state. Possibly, sale cannot be said to be the bad. By operation of law, if I can satisfy your lordship that vesting came to an end in view of the statutory mandate, and vesting was not there when I purchased this land. I tell you, lordship, now kindly turn to, my lord, the page. Page, my lord, 115. Development and Planning Act.
Yes.
My lord, this is a notification under section 4 of the West Bengal Land Development and Planning Act. By which it has been stated that the land in question was acquired under the Act by publication of a notification under section 4. Then, my lord, lordship, kindly turn to page 117. This is a certificate of possession. Then, lordship, kindly turn to.
Give me a second, sir. Mr. Pahan,
My lord.
page number and 115 and 116 are same.
No, my lord, 115 in respect of, my lord, this I got through RTI. That's why I have annexed. This is in respect of, my lord, the Moja. This is a notification such as a lost code heart. This is a first page 115 in respect of lost code heart. My plot will, your lordship will find at page 116. That is at Nonadanga, which is at 340, 640.
No, Mr. Pahan. The governor is pleased to cancel so much of the notification dated such and such.
Yes.
Under section 4 of this, it is a cancellation notification.
Yes.
Section 4. Published at such and such holo. And parts of cadastral survey holo. Very good.
But 640 is not there.
And whereas it appears to the governor, land is needed for public purpose. It is hereby declared that the above pieces of landed are required within the aforesaid place. The decision is made under the provisions of 6 of the West Bengal Land Revolving. So page number 116 is the section 6 notice.
Yes.
Regarding requisition.
Requisition regarding the government is intended to acquire the land.
Yes.
Acquire the land.
So 115 is not
not
required.
Because
your plot number, what is your plot number?
640. That your lordship will find at page 116.
640.
6632 650.
Yes, then it comes under you.
Yes.
So notification under section 6 has been, declaration has been made.
Declaration has been made.
Then what happened?
Then, my lord, এটা জজ সাহেবকে একটু দিন না বইটা। Now kindly turn to, my lord, the section 6 ones of this act. Section 6, your lordship has got it. When a development is sanctioned under subsection 2 of section 5, and the state government is satisfied that any land in the notified area for which such scheme has been sanctioned is needed for the purpose of executing such scheme, a declaration to that effect such land is needed for a public purpose shall, unless already made in the section 7, be made in the state government. So, my lord, the declaration was published. Now, kindly turn to section 8. Section 8. After making a declaration under section 6, the state government may acquire the land, and thereupon the provisions of the Land Acquisition 1894 Act shall, so far as may be, apply. So, after the moment section 8 invoked, then, my lord, on and from section 9, Land Acquisition Act will apply.
On and from
section 9 of the Land Acquisition Act, service notice, award inquiry, everything. Now, lordship, kindly see proviso to section 8. A. If any case the state government so directs, the collector may at any time after a declaration is made under section 6 take possession in accordance with the rules or any bill such and such, anyway such and such, and thereupon such land shall vest absolutely in the free government free from all encumbrances. Then, my lord, I am on B. This is our, my lord, the writ petition is based on subsection B. In determining the amount of compensation to be awarded for land acquired in pursuance of this act, the market value referred to in clause 1st of subsection 1 of section 23 of the said act shall be deemed to be the market value of the land on the date of publication of the notification under subsection 1 of section 4 of the notified area at which the land is included, subject to the following condition, that is to say, if such market value in relation to land acquired for the public purpose specified in subclause 1 of clause D of section 2 exceeds by any amount the market value of the land on the 31st day of December 1946 on the assumption that the land had been at that date in the cell in which it in fact was on the date of publication of the said notification, the amount of such excess shall not be taken into consideration. Now, my lord,
Give me a second.
Land Acquisition Act. Land Acquisition Act আছে?
Yes.
Then, my lord, before I proceed further, kindly have a look at the section 11 capital A of the Land Acquisition Act.
Act 1.
Act 1. Because, my lord, the after section 8, all the provisions of Land Acquisition Act will apply. 11 capital A.
ওই Act 1 of 1894 টা বার করুন। West Bengal Land Acquisition Act 1894. না না আমাদের তো আলাদা আলাদা আছে নি না এখানে নেই land acquisition act West Bengal land acquisition এই তো West Bengal
Now, kindly, my lord, have a look at the section 11 capital A. You also got it. The collector shall make an
just a minute. Yes.
The collector shall make
Period
an
with period within which an award shall be made. Section 11A, period within which an award shall be made.
So, my lord, the collector shall make an award under section 11 within a period of 2 years from the date of the publication of the declaration. And if no award is made within that period, kindly mark the entire proceeding of the acquisition of the land shall lapse. My lord, this section came into effect on and from, my lord, 24th of September 1984.
Which one?
This section 11 capital A. It was 1984 by way of 1984 Amendment Act. This was introduced, incorporated in the statute with effect from, my lord, 24th of September 1984. My respectful submission before your lordship will be this, my lord, that any declaration published earlier to this, before coming into force of this section 11 capital A, latest by 23rd of September 1986, award ought to be been made within 2 years. If not, then entire proceeding will go. Not only the section 4 notification or section 6 notification, entire proceeding.
So according to you, award is to be declared on or before 23/9/2019-86.
86. Now,
Otherwise, it will lapse.
Entire proceeding, not section 4, not section 6, entire proceeding. Now, if I can satisfy your lordship that there was no valid award as on 23rd of September 1986, then, my lord, my respectful submission before your lordship will be this: entire proceeding lapsed.
No valid award means award was not published.
No valid. Why are you using this valid award? If there is no valid award in the eye of law, then, my lord, entire proceeding gone, including the alleged vesting.
But the word is no award is made.
No award is made.
Then why are you using this word?
My lord, tell your lordship. Now, my lord, here, after filing of this writ petition, after filing my RTI, then I was served with certain documents, including the award sheet, which has been passed. Date has not been mentioned because I could not find any date. In their affidavit in opposition, they have also not mentioned any date as to when this award was passed. Even assuming, my lord, the award was passed, even then that award is nullity in the eye of law, since this was declared taking into consideration subsection B of section 8. Why so? Which has been declared ultra vires, which were declared ultra vires by the Supreme Court as well as our High Court. So, therefore, my lord, any award passed taking into consideration proviso to section 8B is nullity.
No, if any award is passed under section 8 subsection a clause proviso B.
Yes. Then award is non-est. Because provision has been declared ultra vires by the Supreme Court as well as our High Court. And I will show to your lordship's own judgment on this point. And later on, I will show to the judgment, because here, my lord, what the thing has been developed. When they used an affidavit in opposition, in the affidavit in opposition, they have said
which has been declared ultra vires? Section 8 has been declared ultra vires.
Section 8B. देखिए judgment है.
In the event that has been declared ultra vires, then what will be the effect?
Effect, the proceedings lapse in view of section 11 capital A, they have to acquire a press vesting gone, because award ought to be made or ought to have been made within 3rd of September 1986. Based taking into consideration the valid section 4 and section 6. On the basis of the self-same section 6, no award can be passed after 23rd of September 1986. এটা নয় দেখি আমাকে দেখি.
No, then under the Act of 1948,
Yes.
then how, for the sake of argument, if I accept your contention that there has been declared ultra vires, then how the award is to be made?
Then, my lord, market value also as on that day prevailing, that has to be paid, not on the based on the 1946 valuation. That part has been declared ultra vires. My lord, if your lordship kindly see, I had an occasion to place this judgment before your lordship. This is a 5 judges bench judgment of the Honorable Supreme Court, reported, my lord, in Supreme Court reports, 1954 Supreme Court reports, page 558. It's a famous judgment. 1954 Supreme Court reports, 558. Now, my lord, if your lordship kindly turn to page 564 of that reported judgment, dealing with the later part of the section 8.
Page number
564. The relevant portion I am relying. The question which has come from your lordship is answered to here.
Yes.
This is the 53. This is the 1953 judgment was delivered. So subsequent to this, any award is being passed is ultra vires, declared ultra vires on this provision. Turning now to the provisions, because here, my lord, the acquisition was made in the year 1956. Now, my lord, turning now to the provisions relating to the compensation under the Impugned Act, it will be seen that the latter part of the proviso to section 8 limits the amount of compensation so as not to exceed the market value of the land on December 31st, 1946. No matter when the land is acquired, considering that the Impugned Act is a permanent enactment and lands may be acquired under it many years after it came into force, the fixing of the market value on December 31st, 1946 as the ceiling on compensation without reference to the value of the land at the time of acquisition is arbitrary and cannot be regarded as due compliance in letter and spirit with the requirement of Article 31(2). The fixing of an anterior date for the ascertainment of value may not, in certain circumstances, be a violation of the constitutional requirement. And for instance, when the proposed scheme of acquisition becomes known before it is launched and prices raise sharply in anticipation of the benefits to be derived under it. But the fixation of an anterior date, which might have no relation to the value of the land when it is acquired, maybe many years later, cannot but regarded as arbitrary. And accordingly, my lord, this was declared ultra vires. We accordingly hold that the latter part of Proviso 8B to Section 8 of the Impugned Act, which fixes the market value on December 31 as the maximum compensation for land acquired under the offence against the provision of Article 31(2) and is unconstitutional and void. Now, my lord, the stands taken by the state, I like to refer what is their stand. I shown to your lordship, my lord, that after Section 8, all the provisions relating to the compensation.
Give me a second, sir. So if that portion is declared unconstitutional,
Yes.
but the main portion of clause B remains.
Clause B remains. So
therefore, the market value of the land would be the market value on the date of publication of the notice under Section 4.
Section 4. If award would have been declared
In compliance with that, within that time limit.
Within that time limit, I have no case. Then I will come to the later part, my adversary right or something, or etc. etc. Now, my lord, I tell you, lordship. Now, kindly see, my lord, what is their opposition?
Now, who are you?
From
whom the acquisition took place?
Acquisition took place against
from your predecessor in interest.
Predecessor in interest. He was not paid anything. And that is the case of the respondent.
They are the subsequent purchaser after post-acquisition purchaser.
No, what is your local stand?
Landowner, predecessors of the minor.
No, he was not your predecessor in interest. The land was acquired from your vendor's predecessor in office. Then what is your local stand?
I am not challenging the acquisition proceeding. I have challenging anything. I am saying the fate of that proceeding as well as the status of the land when I purchased the land. When I purchased this land was free from all income, from any vesting. Land was not vested with the state. If this had been within
by operation of law.
By operation of law. By operation of law. And similar situations were dealt by your lordship.
Very good.
Now, my lord, kindly see, my lord, what is their case? If your lordship kindly turn to their opposition.
Yes.
Now, kindly turn to, my lord, to the page 4.
Yes.
What starts with, my lord? Verification of files. Page 4.
Mr. Portobel, please ask your clerk to restitch it because this portion of this is torn. It was stitched. No, it was stitched. I believe it was properly stitched. Now it have some papers have come out.
It is our fault.
So please ask your clerk to stitch.
একটু আসতে বলো একটু আসতে বলে ভালো করে সেলাই করতে বিশুদ্ধ ডাক বলো এখানে আসতে সেলাই করতে একটু টেকে নাও
থেকে ছুঁচতে নিয়ে আসিস পুরো ছেঁড়া করবি
Page number 4, sir.
মানে পেজ নাম্বার 4
মেয়ে আছে মাইন্ডকে সেলাই করতে
Yes.
মানে 7 small ii that on verification of files
Huh.
and registers lying in the office of the special land acquisition South 24 Parganas, it appears that CS plot number 640 Mauja Nuananga police station such and such, including land in Mauja such and such, under same police station was declared to be acquired under section 6 of the West Bengal Land Development and Planning Act by notification such and such duly published in the for public purpose, namely the settlement of immigrants who migrated into the state of West Bengal on account of circumstances beyond their control. But kindly pause for a moment over here, Lordship, that I have shown to your office, my lord, there is a my lord, the information I sought for from the department. They said no squatter has been constructed over there. The physical possession of the cell measuring ground about such and such.
They used to provide information without consulting.
My lord, I am not on that. My lord. All 5 Mojas, Ingore Mouda, Relief and Rehabilitation Directorate on Athuk from 15 September, 15 January 1957. So, up to 15 January 1957, there was no award, admittedly.
You are reading from which portion?
That paragraph I shown to your lordship
Was declared to be acquired under section 6 of the Act,
yes.
date 1611 and duly published in 6/12/1956.
1956.
That you have also annexed.
Yes. For public purpose, namely the settlement of immigrants who migrated into state of West Bengal on account of
1611. It means 1611/1956.
That is section 4.
19774.
Yes.
It's matching.
Because that they have provided me this thing.
Notification at 1611 or published holo kabe?
Published to 6/12/1956.
6 December.
6 December.
Published on 6 December. Yes. Matching.
Then, my lord, namely the settlement of immigrants who migrated into the state of West Bengal on account of circumstances beyond their control. The physical possession of the said land measuring about such and such in all 5 users was handed over to the KGO Refugee Relief and Rehabilitation Directorate on 15 January 1957. Now kindly mark that portion, my lord. Next, the award being award serial number 228 amounting to rupees 446.61 against acquisition of said plot number Moja was prepared in the name of the recorded owner, namely Bholanath Gwaldar, son of such and such, and deposited as revenue deposit by check number such and such under section 11 of Act 1 of 1894. Kindly pause for a moment over here. Now kindly, my lord, kindly take the section 12 first. Kindly take the section 12 first. First of all,
12 of what?
Act 1. Because Act 1 will apply.
Naturally.
So section 12. Before that, section 11, kindly.
Oh, just a minute. এইখানটাকে মানে এমন ভাবে করতে যেন এইটার মধ্যে থাকি।
matters is there, my lord. 59, 60 and 61. I am for the 61 matter. My learned friend will contact this case for similar matter. Changes. 51, 50 and 61.
Mr. Bandyopadhyay is appearing in 59 and 61.
I'm at 59, Mr. Day is minus 60.
And who is in 61 then?
No. Possible to 60.
Mr. Ganguly,
Mr. Ganguly is.
তারা একটু 59 থেকে 61 করে দেন না তাহলে অসীম চলে আসবে।
No, they cannot. It will be otherwise. It will. There is an order. There must be an order of tagging then.
ও আচ্ছা।
ওই WT করে করতে হবে
আচ্ছা আচ্ছা।
উইথ নেক্সট ডেতে তাই ক্রসে করবে।
Oh, my lord, original say this.
No idea. But in our own cabinet side, why not? This process will continue. I know it also. The order has been told. Why
We are not. We know that your lordship is from our side only. So that's why your lordship knows.
I am acquainted with the.
Yes, in the process of holding this chair.
No.
Before that.
During my practice.
Also. Yeah, I know. Well,
তুমি যে খারাপ না তুমি তো ভালো নিয়ে আসছো মাছটা দিচ্ছ তুমি আমাদের তুমি এমন একটা অর্ডার করে নিচ্ছ সেটা মাইলর থেকে আমরা তো সেখান থেকে ধরছি
What for practice, my lord? It is the main idea that you know everything. Otherwise, it is not possible.
আমরাও করেছি।
না হাইকোর্টে অত
হ্যাঁ, আমরা আমাদের চেম্বারে করেছি।
হাইকোর্টে
Yes, in our chamber we did this.
my senior court
under section 9 it and into the value of the land at the date of publication of the notification under section 4.1 and into the respective interest of the persons claiming the compensation shall make an award under his hand of the true area of the land, the compensation which in his opinion should be allowed for the land, and the apportionment of the said compensation among all the persons known or believed to be interested in the land for of whom or who of whose claims he has information whether or not they have respectively appeared before him, provided that, let us skip over for this moment, we provide so. So therefore, my lord, section 11 does not empower the collector or anybody to deposit any amount of compensation into the as a revenue deposit. But my way of understanding of the revenue deposit is this, my lord, that if I am an awardee, but payment has not been made to me, I cannot withdraw the money from the revenue deposit.
Petitioner is not the miller, the
আমি কি বলছি আগে শুনুন আমি কি বলছি আমি আমার কথা বলছি পিটিশনে আমি অমিত পান হিসেবে বলছি but if any amount has been award has been declared in my name and money has been deposited with a revenue deposit, I cannot withdraw that. Otherwise, if it is deposited in the court, I can, after satisfying the court, I can withdraw that money. So revenue deposit cannot be said to be the deposit under the head of compensation. Under the head of compensation, my lord, no revenue deposit can be made.
But award was not passed in your favor.
My lord,
Award was not passed in your favor.
in favor of the my predecessor. That exactly
Not
what
predecessor, your vendor.
vendor, my vendor. That's a predecessor, my vendor. They have said so, prepared, not declared. They have said award prepared. For the argument's sake, I am saying I am accepting that award declared.
Yes.
Declaration and preparation is hell and heaven different. Preparation is something different and declaration is something different. They are saying the award prepared. Next sentence is revenue deposit under section 11.
It has got to be deposited in a court.
Now kindly, my lord, see next page. Now what they are saying. Here they are saying section 11. Next page, kindly have a look at the section 4, page 4. Page 4. Page 4, I have placed before your lordship. Then turn to my lord the page 7. Page 7. Page 7.
Yes.
My lord, third line from the top.
Hmm.
Award has also been declared being award serial number such and such in the name of the recorded owner such and such and deposited as revenue deposit by chair number such and such under section 12. Here they are saying under section 11 deposit was made. Now they are saying under section 12 of Act 1 of 1894 that was made. My lord, for the argument's sake, my lord, I am accepting either of these two provisions amount was deposited. Now question before your lordship will be this, my lord, whether they can deposit even under section 12, possibly not. Kindly have a look at the section 12. What is section 12 meant for? Award of collector when to be final. Such award shall be filed in the collector's office and shall, except as hereinafter provided, be final and conclusive evidence as between the collector and the person interested, whether they have respectively appeared before the collector or not, or of the true area of and value of the land and the apportionment of the compensation amongst the person interested. The collector shall give immediate notice of his award to such or the persons interested as are not present personally or by their representative when the award is made. So, my lord, there is no whisper by under this provision any amount can be deposited as revenue deposit as has been stated in the affidavit.
You refer section 12.
Section 12, they have said so. Under section 12, they have the revenue deposit was done.
Very good. Then what happened?
Then, my lord, when this deposit can be made, kindly turn to, my lord, section 31.
Reference.
No, section 31, my lord. That is the only provision which empowers the collector to deposit the amount into court.
On a reference.
Section 18, my lord, is the reference. And 31 says payment of compensation or deposit in the court. Deposit into the court. Now, my lord, what are the contingencies that can compel the collector to...
No, Mr. Pan, I understand.
Yes.
That it should have been deposited in court.
In court. So therefore, my lord,
how you are going to be prejudiced? If prejudice is caused to anybody, that is your vendor.
No, my lord,
how you are going to be prejudiced?
Why I am saying this? Because I purchased this land. I have to satisfy your lordship. On the date of purchase, vendor has got the right title interest to sell out the land. Land was not vested with the state.
That you satisfy.
Now, my lord, I shown to your lordship, my lord, the award which has been declared is a nullity. There was no award in the eye of law. Because award has been declared.
That you have stated, you have not sold. That you have stated, we have not sold as yet.
Shown.
You have not sold that.
Yes, I have shown to your lordship.
You have shown?
Yes.
The provisions of...
Yes.
Provisions of section 4, I'm sorry, section 8B.
Yes. Now,
lordship, and the subsequent portion which has been declared unconstitutional.
Yes.
Then now, what happened?
Then, my lord, if any award has been declared taking into consideration of that part, subsection proviso to subsection 8B.
8B, latter part.
Latter part, that the determination of market value, that part. If that is ultra vires.
So wherefore will get that the award has been quantified considering the latter part, that I
yes, but kindly take my supplementary affidavit. I have categorically said so. Categorically said so.
No, you say what document do you have that while passing the award, this portion has been taken into consideration?
Because they have nowhere said. Because I am telling your lordship that taking into consideration the provisions of the West Bengal Land Development Planning Act, award has been declared. Provisions include because
I understand. I understand that when the after declaration you have said section 8 says the award has to be declared in terms of Act 1.
No. Award is to be declared under section 8B.
8B.
And taking into consideration the other provision of Act 1, that is, my lord, section 23. 23 deals with what are the other benefits that will be that will get. Determination of market value is to be done under.
Very good, sir.
No, kindly give me 1 second time. 1 second time. Possibly I could not make myself clear to your lordship. They have determined the market value of the land. Market value of the land, taking into consideration the later part of section 8B.
Wherefore we'll get that?
But that is their award from the award sheet itself, because they have because that is the only provision by which 1948 Act can be invoked. Otherwise, this has to be amended.
It may be that the latter part has not been considered only by
otherwise there cannot be any market value, because there is no amendment to this after declaration ultra vires. After declaring this provision ultra vires.
Mr. Pan, try to understand what I am asking.
Mal.
You have referred section 8, which says that after declaration, the provisions of Act 1 will apply. Am I correct? Now, it contains...
Act 1 of what? Act
1894.
Now, Act 1 for purpose of that has been said for the purpose of...
Thereupon the provisions of the Act 1 of 1894 will apply.
In the proper refer to the provided that there is a proviso.
I'm on that proviso.
Market value is to be determined under subsection B only. Market value cannot be in the other way.
So in determining the amount of compensation to be awarded
The
for
market
land
value.
acquired in pursuance of the market value referred to in clause first of subsection 1 of section 23 of the said shall be deemed to the market value of the land on the date of publication of the notification of section 4 which means the land is subject to the following condition. Maybe they have not considered the latter part. How the code will come?
I am showing a document of them. Acharji supplementary affidavit देखिए Acharji supplementary affidavit. In respect of the self-same malor the proceeding, I filed 3 writ petitions. Appearing 61, 62, 63. In one writ petition, supplementary affidavit. In one writ petition, I have annexed a document of them.
No, in this writ petition, have you annexed any award?
Award I have annexed.
Where?
Yes.
So
at page, এটা না আচার্যির না একটা ডকুমেন্ট আছে না ডকুমেন্ট দিয়েছিল পরে দেখ ডকুমেন্টটা আছে
where is the award which has been published in connection with the land acquisition proceeding?
Yes. At page 118.
118. Let me see what is there. Mr. Pan, try to understand my question.
Yes, I got your lordship.
From the award,
yes,
how do you establish that the authority, while declaring the award, not only concentrate himself to the first part of proviso of clause B, as well as the latter part of the clause B? Where from will get that?
No, my lord, in the
that is required. Because you are not the awardee.
I fully appreciate. My lord, I am just saying
the fate. I can't understand, my lord. When he is a post-proceeding particular, my lord, after that he is not challenged the award. He challenged the proceedings. Challenge the proceeding. How, my lord, he argued on the process of this.
My lord, in my I am sorry to say, my lord, in my petition, I have never challenged any proceeding.
Then, my lord,
I have never challenged. I have said because I was served with a notice for stating me that a trespasser. That's why I have said all these things. That I cannot be said to be the trespasser. I have purchased I am holding a good right title interest of the land.
What Mr. They intends to contend.
Yes.
If I have properly understood.
Yes.
That when your vendor had not accepted the award, had not challenged the award, then what locus standi you have got?
I have not
to substantiate.
My sorry to my lord, with due respect, I need not to. My vendor need not to, because my vendor was not served with a notice for award. My vendor was never been served with any notice in respect of that proceeding.
So if there be any grievance, that is there. That is with the
kindly see.
vendor.
My grievance, I am agitating my grievance when I was termed as a trespasser in respect of the land in question. There I am joining.
Ultimately, you are challenging the award.
No. I have not.
Ultimately, you are challenging the acquisition proceeding.
Lordship connection. I am saying the fate of the award, not challenging the award. I am saying the
you are challenging the proceeding, acquisition proceeding.
I am saying that
according to you, according to you, the proceeding has lapsed.
Yes, well, by operation of law. On 2013, when I purchased this land, that land was never been vested with the state. That is my first contention.
My lord, he can't say so. He can't argue on that point.
Well, my learned friend will get his turn. Will get his turn. Don't be. আপনিও তো আপনি লিখে you will get your turn, please. So, my lord, what I am saying,
Yes, sir.
my lord, I have to. Yes, 3:30. Today is 3:30.
কালকে হবে পরে একদিন একটা ডেট কালকে না আর কালকে আমি কি করবো কালকে তো অন্য
Supplementary affidavit. I was served with a document wherefrom it will be evident that taken the considerance of market value of 1946. Yes. Yes.
হ্যাঁ একটু চাই
নেক্সট ডেট কবে হলো হ্যাঁ 16 জুলাই সুজয় 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 এই পাতাগুলো একটু জেরক্স করো তো সুজয়
এই সোমবার হবে, কালকে হবে না। হ্যাঁ সোমবার হবে।
কালকে হয় না, কালকে তো মোশন
কালকে তো হবে না।
ফার্স্ট হাফে একজন মোশন আর সেকেন্ড হাফে মোশন ল্যান্ড মোশন কালকে কি করে হবে মানডে সোমবার মানডে হলেও আমরা করবো না এই কালকে হলেও আমরা করবো না
হ্যাঁ
এই দুটো করে নাও
আজকে কিছু আছে